All rise. The International Criminal Court is now in session, hosting the ICC Moot Court Competition 2026 English edition. Please be seated.
Microphone is on. Thank you. I would like to greet the teams participating, counsel for the defendant, counsel for the government, and counsel for the office of the prosecutor. I welcome as well the courtroom staff, the security officers who diligently assist us during our work. I should also greet all those attending from the gallery, the participants in the ICC Moot Court competition attending this hearing, and those outside the court joining us this afternoon via the internet in this Moot Court competition. This is the way the legitimacy of this court is always crafted and built. So I welcome you all attending this hearing. I would now turn to the court officer and ask to call the case, please.
Thank you. We are sitting in appeal session regarding the pretrial chamber's confirmation of charges in the case of the prosecutor versus Dragana Syrax in the situation of the state of Essos, ICC Moot Court Competition 2026, English edition.
Thank you. On behalf of the chamber, I would now ask the parties and the participants in this hearing to introduce themselves, starting from the counsel for the defendant, which brings the appeal. Note that fairness of the process is not limited to the textual confines of the statute. Fairness of the process, I'm appealing to all parties and participants. It's being brought to life by joint efforts of all participants and parties. And it starts from the very perhaps small but important element. And I would like to ask parties and participants to speak slowly and to pause before responding to any question in order to allow all participants to follow closely. Could I ask you, counsel for the defendant, to present the members of your team, please?
Certainly. Mr. President, Your Honors, may it please the court. My name is Natasha Lim, and together with my co-counsel, Mr. Basil Chia, we appear for the defendant. Thank you, Your Honors.
Now I turn for the counsel for the government, participating under Article 19(2)(c) of the Rome Statute. Could I ask you, counsel, to present the members of the team?
Mr. President, Your Honours, my name is Lachlan Crozer, and today, alongside my learned co-counsel, Kathleen Trafford, we appear on behalf of the Democratic Republic of Marine.
Thank you. I now turn to the counsel of the office for the prosecutor. Counsel, could you please present the members of the team?
Good morning, Your Honors, Mr. President. I am Aisha Khan, and this is my co-counsel, Pradnesh Kamath, and we shall be representing the Office of the Prosecution in the present matter. Thank you.
Thank you. The team of the registry is represented today by the court officers, Wilfred Dungu, Ludovica Esposito, Max Derek Fulham, Anna Miller, and Anna Maria Rosenova Georgieva from the Grotius Center for International Legal Studies. Finally, or perhaps I could have done it from the very beginning, I would like to introduce the bench. To my right is Judge Sophie Kortmans, and to my left, Judge Magali Bobbio, and I'm Judge Kochal Ortipanidze presiding over this appeal. The Chamber will now proceed consecutively with the three issues shaping the subject matter of today's hearing. Being mindful of the public nature of this hearing, I would ask the court officer to please read the agenda established by the appeals chamber.
Thank you, Mr. President. Pursuant to Pre-Trial Chamber 15's decision to grant the defense's request for leave to appeal the confirmation of charges of 15 September 2025, the appeals chamber seeks submissions of the parties and participants on the following three issues. A, whether the pre-trial chamber erred in concluding that the prosecution had established substantial grounds to believe that the defendant, Dragana Sirax, ordered the war crime of impeding the delivery of essential medical aid within the jurisdiction of the ICC under Articles 8.2b3 and 25.3b of the Rome Statute. B, whether the pretrial chamber erred in concluding that the defendant could be tried by the ICC notwithstanding her status as the sitting head of state of Marine. And C, whether the pretrial chamber erred in rejecting the defendant's argument that the case must be dismissed because of the irregular means of her rendition.
Thank you, court officer. I will turn now to the defense to present its submissions on those three issues of the discussion. Thank you.
Mr. President, Your Honors, may it please the court. As earlier introduced, my name is Ms. Natasha Lim, and I act for the defendant, President Dragana Sirax, in today's appeal. I will take this court through the three prayers on the agenda for 20 minutes, and I respectfully reserve 10 minutes for rebuttal. Your Honors, today's appeal arises out of the kidnapping of a head of state. President Sirax was forcibly abducted, stripped of her head of state immunity before the pre-trial chamber, and charged for a crime whose conduct occurred outside the territory of any state party. This sequence of events marks a departure from the principle that underpins this court's legitimacy, namely that justice must be exercised within legal limits. For these reasons, we ask this court to allow today's appeal because the pre-trial chamber erred in three respects. First, there are no substantial grounds to believe that a war crime occurred within the territorial jurisdiction of this court. Second, President Sirax cannot be tried before this court due to her head of state's immunity. And finally, the irregular means of how President Sirax was brought before this court requires a dismissal. I now begin with the first prayer. The incident which forms the basis of the prosecution's charge occurred on the 12th of February 2025, where a Marine ship fired non-lethal tracer rounds at a Dothraki vessel. We make two submissions on the first prayer. First, this court does not have territorial jurisdiction because this incident did not take place on Essex's territory. And second, in any event, the crime of attacking a humanitarian assistance mission has not been made out. Now, on the first point, Your Honors, Article 12, subsection 2A of this court's statute provides that this court can exercise territorial jurisdiction if the conduct in question occurred on the territory of a state party. Now, the record makes clear that this incident occurred outside of Essex's territorial waters. If I may quote paragraph 12 for Your Honors, it states that, and I quote, "The Marine blockade ships were positioned just outside of Essex's territorial waters." And under Article 3 of the United Nations Convention on the Law of the Seas, it confirms that the territorial sea only extends to 12 nautical miles, whereas this incident occurred at the 15 nautical mile mark. But the crux of this issue is whether, as the prosecution suggests, this court can exercise what is called the effects doctrine of territorial jurisdiction. We say that the court cannot do so because the word conduct in Article 12 refers only to the crime and not consequences for two reasons. Now, the first reason is the wording of the Rome Statute itself. Time and time again, this statute distinguishes between conduct and consequence as two different terms. For example, paragraph 7 of the General Introduction to Crimes provides, quote, "A crime consists of conduct, consequence," end quote. Now, similarly, Article 30 in this court statute distinguishes between mental elements for conduct and a mental intent for consequence on the other hand. And so this shows that on a textual level, conduct in Article 12 is not to be equated with consequence. But the second reason, Your Honors, why this effects doctrine cannot be applied is because it is not supported by this court's very own jurisprudence. Specifically, in the 2019 Pre-Trial Chamber 3's decision on Bangladesh and Myanmar, the court could have chosen to exercise effects doctrine. In fact, it was a factual finding that over 1 million Rohingya refugees had been deported into the state of Bangladesh. But the court did not adopt such a far-fetched approach. Rather, it confined its territorial jurisdiction to a narrow rule known as the objective territoriality approach, which requires an element of the crime to be completed in another state's territory. It is for these two reasons that we say, contrary to the prosecution's suggestion at paragraph 15 of their written memorials, that this court cannot exercise territorial jurisdiction. I now turn to address the merits of the charge, where we say likewise the prosecution's case fails. Now, we challenge the first element of the crime, namely that an attack did not occur. The question for this court today is, when this court looks at paragraph 12 of the record, were the non-lethal tracer rounds warning shots, or were these actually attacks? We say it was the former, a warning, for two reasons. Now, the first is that an attack has been defined by this court as an act of violence against the adversary, as found in the Taganda decision. And it is clear that a tracer round, which was non-lethal, is not such an act of violence. But the second reason why a non-lethal tracer round is a mere warning is because of the maritime practice of warning shots. Your Honors, when it comes to the law of the sea, warning shots are visible indicators originally used as gunpowder. Now, we see a similar manner in the facts. a trace around is designed to leave a visible trail of light, and that is the exact modern practice of a warning shot. Now, our position is supported not just by maritime practice, but jurisprudence from the Tribunal of the Law of the Sea. For example, in the MV Sega case at paragraph 156, the tribunal accepted that an auditory or visual signal is to be used as a warning, not an attack. And we see that made out in the present case. But there is an additional fact which we wish to point to this court. Namely, at paragraph 12, the facts also show that this tracer round was fired across the ship's bow. Now, it is now idiomatic that the phrase across the bow of a ship is meant to signal a warning or an intention to stop. Therefore, taken in totality, the facts describing the incident on the 12th of February do not rise to the level of an attack. But before I turn to the second prayer, I wish to address the prosecution's contention that the definition of an attack should be given a less strict meaning. Now, they say that an attack is merely one that impinges on the liberty of a peacemaker, and they draw this support from the SCSL, the Special Court for Sierra Leone's decision of Sase. But we say that, with respect, that decision and its definition of attack should not apply to the present case, because this court's jurisprudence has confirmed that an attack must carry the same definition across all of Article 8 unless there is explicit wording to the contrary. This comes from the 2021 separate opinion of Judges Hamadsky and Morrison in the Taganda decision at paragraph 8. So because this special meaning is not found as an express indication, then we say that the warning shot does not arise to the level of violence which this court defines is to be an attack. With that, I turned to the second prayer, namely that of immunities, where we wish to point another difficulty in the prosecution's case. Your Honors, I wish to be candid that we recognize that domestically it is a customary rule that heads of states enjoy immunity before each other's foreign jurisdictions. But the question for this court is, what gives this international court the legal basis to ignore a head of state's immunity? Now, we say that this is complicated by two facts on the record. Namely, at paragraph 9, there has been no UNSC referral. At paragraph 14, Marine, who I act as counsel for, is not a state party to this court statute. We therefore say that our client has immunity for two reasons. Now, the first is the text of Article 27, which we begin as a manner of interpretation. Your Honors, Article 27 provides that this statute shall apply equally to all persons without any distinction based on official capacity. Now, at first blush, these words seem to be broad, but what we must remember is Article 27 is a provision that sits within a treaty, and it is the cornerstone of treaty law that a treaty cannot bind non-state parties. This is not just my assertion. It comes specifically from Pre-Trial Chamber 2's 2014 decision on the cooperation of the Democratic Republic of Congo in the al-Bashir referral at paragraph 26. Now, if I may quote that judgment, it says that given that this statute is a multilateral treaty governed by the rules set out in the Vienna Convention, the statute cannot impose obligations on third states without their consent. Now, this is sufficient to conclude the case on immunities. But we wish to add an additional layer, which is that because of this court's mechanisms in the nemo dat principle of jurisdiction, likewise, our president does enjoy immunities. Now, what I mean by the nemo dat principle is that states can only confer on this court the maximum of jurisdiction they have. Now, this finding was endorsed in the pre-trial 3 chambers decision of Bangladesh and Myanmar at paragraph 55. And so the logical consequence of that here, Your Honors, is that if states cannot prosecute each other's head of state at the domestic level, then they cannot give such a power to the court. Finally, unless there are further questions, I turn to address our third prayer, namely that on how our president was brought to this court. Now, Your Honors, we wish to note that we stand today at an age where some people might view the rule of law, unfortunately, as optional. Now, this is exemplified in how our president was brought to this court. Paragraph 20 of the record shows that, and I quote, Cyrex was forcibly removed, anesthetized, and presumably still unconscious, placed on a private jet here to The Hague. This is not surrender. This is abduction. And this court cannot stand for such conduct, especially in today's age. We say this case must be dismissed for 2 reasons. First, the doctrine of male captus bene detentis, which the prosecution relies on, does not apply to this court. And second, that a dismissal is required under the abuse of process doctrine. If I may address the male captus principle, we note that the prosecution suggests that it is a customary rule or a general principle of law, but this is incorrect. In fact, the states who had earlier endorsed this principle of bad capture, good detention, have now turned a 180 reversal and rejected this doctrine, such as the US, the UK, New Zealand, South Africa, and France in cases like United States and Toscanino and Re Bennett. This shows that such an archaic principle cannot apply to this court because its very proponents have now rejected its applicability. And likewise, we say this court should also adopt the same. Now, there is no reason why this court, even if an accused appears beaten black and blue at its doorstep, can simply ignore such a violation and say that there is good detention. This principle cannot be applied today. I turn to address the second point we preface before this honorable court, that a dismissal is required because of the violations of our president's rights. Now, to be clear, in the 2006 appeals chamber decision of Prosecutor and Lubanga, the court recognized that this court can grant a dismissal if there are 2 cumulative requirements. First, there must be a violation of the accused's rights, and second, a quote-unquote fair trial is impossible. Now, the first element is relatively uncontentious. Now, cases have confirmed that when a suspect has been given anesthesia for no medical purpose, then this is a violation of the right to liberty in Article 9 of the International Covenant on Civil and Political Rights. But the second element is what we wish to address today. Now, we note that the prosecution may suggest that a fair trial merely concerns the 4 corners of this court. We accept that our client has been given legal counsel, has been confirmed of the charges. But in Lubanga, the court took the pains to confirm that a fair trial is not just this trial process, but, if I may quote paragraph 39, extends to the judicial process in its entirety, including how an accused has been brought to court. Therefore, given that Dothroki's actions violated President Cyrex's rights, then this meets the fair trial definition in Lubanga, which is not strictly confined to process. But before I conclude my point on this prayer, I wish to address the prosecution's submissions that attribution is required for this court to grant a dismissal. Now, the effect of what the prosecution is saying is that the court can simply turn a blind eye so long as its hands are not involved in the process. Now, this is a far cry from what this court should stand for as an institution. But further to this, in the 2021 separate opinion of Al-Hassan, the court confirmed that attribution is not a requirement. Likewise, in the Lubanga judgment, the court found, if I may quote for your excellencies, that absent concerted action, the abuse of process doctrine serves as an additional guarantee. What this means is that even if there is no concerted action between this court and the wrongful captors, that does not mean this court can simply turn away. Therefore, in light of my time, I wish to conclude with our final observations. Ultimately, Your Honors, this case is about more than just legal technicalities. It is about the legitimacy of this very court itself. A court that exceeds its boundaries does not deliver justice, but we trust that this court can deliver such an objective to our client. Unless there are any further questions, this brings me nicely to the end of my submissions. Thank you, Your Excellencies.
Thank you, Counsel. In order to have clarity and proper management of this hearing,
Certainly.
I would clarify the matter that the questions will be asked after all submissions are heard by the bench, and it will give also equal opportunity to all parties and participants. So with that, I will now give the floor to the Counsel of the Government.
Mr. President, Your Honours, once again, my name is Lachlan Crozer, and today, alongside my learned co-counsel, Kathleen Trafford, we appear on behalf of the Democratic Republic of Marine. Your Honours, the Government of Marine does not wish to impede this court's role in putting an end to impunity. Rather, it invites Your Honours to consider how that goal is truly fulfilled. Your Honours, the Government submits that as a court that fundamentally operates on the basis of sovereign consent, that goal is fulfilled through strict adherence to the limits imposed on this court in the Rome Statute, as well as adherence to the principles of sovereignty that have governed international law since Westphalia, principles created not to shield individuals from personal liability, but created to ensure the peaceful coexistence of nation-states. Your Honours have an opportunity today to realign this court with those founding principles, to ensure the legitimacy of this institution in the international community, and overall, to place this court in the best possible position to put an end to impunity for generations to come. Your Honours, pursuant to its right of standing under Article 19(2)(c), the Government wishes to address the following three submissions. First, that the pre-trial chamber erred in finding that this court can exercise jurisdiction as the preconditions to its exercise of jurisdiction outlined in Article 12(2) of the Rome Statute have not been satisfied. Second, that the pre-trial chamber erred in finding that this court has the requisite jurisdiction to prosecute an incumbent head of state of a non-state party to the Rome Statute. And finally, that the pre-trial chamber erred in finding that this court should retain jurisdiction to prosecute the defendant, irrespective of the illegal means of rendition perpetrated by the Dothraki government. Your Honours, to that end, the Government of Marine respectfully requests to join the defence in requesting that this court reverse the impugned decision of the pre-trial chamber in its entirety, pursuant to Rule 158.1 of the Rules of Procedure and Evidence. Now, Your Honours, before addressing the substance of my submissions, it is appropriate to address the current standard of today's appeal. Your Honours, given that the nature of this appeal, Your Honours must find that there is a material error of law in which would materially affect the impugned decision, such that the chamber, in first instance, would have rendered a decision that is substantially different from the decision that was affected by the error if it had not made the error. And that was pursuant to the prosecutor against Joseph Coney in 2025. Your Honours, before addressing the substance of my submissions, the government will also address their standing pursuant to Article 19.2c. Under Article 19.2c, a state is afforded a right of standing before this court to address jurisdiction and admissibility of a present case if their acceptance of jurisdiction is required. Notably, Your Honour, this court's purported territorial jurisdiction, as noted by counsel for the defence, relies solely on Ess's ad hoc acceptance of jurisdiction under Article 12.3. Given that the defendant, President Syrax, is a national of Marine, a non-state party to the Rome Statute, they have standing to contest this court's current means of jurisdiction. This right has been affirmed by this very own court's jurisprudence in the Appeals Chamber decision of the situation in the state of Palestine at paragraph 62. Your Honours, I will now turn to my first submission, which pertains to the preconditions of this court's exercise of jurisdiction. The government submits that the pre-trial chamber erred in finding that the conduct in question occurred in the territory of the state of Essex, as required under Article 12.2a. Now, notably, that is the question before this court, as the precondition to this court's exercise of jurisdiction must be established, as the investigation was initiated propria muto. Accordingly, Your Honours, the prosecution must either show, under Article 12.2b, that they can establish jurisdiction through the nationality limb, which is immediately foreclosed as the defendant is a national of Marine, a non-state party, or the territoriality limb of Article 12, that of Article 12.2a, which puts forth that the court will have territorial jurisdiction, whereas the crime, or rather the conduct in question, occurred on the territory of a state party, or the crime was committed on board a registered state party vessel or aircraft. Now, Your Honours, counsel for the defence has correctly identified that the applicable principle of law before this chamber in determining territorial jurisdiction is that of objective territoriality. They have correctly highlighted that the blockade was located outside the territorial waters of Essex, and as such, at an absolute minimum, it must be shown that at least one actus reus element of the crime occurred in the territory of the state of Essex. And that is pursuant to the decision rendered by the third pre-trial chamber in the Bangladesh and Myanmar situation, whereas the court noted that the only obvious limitation imposed by the wording of Article 12.2a is that the conduct in question, or rather it means that an actus reus element of the crime must occur in the territory of a state. This comes from the fact that the court found at paragraph 48 that conduct in question carries the same functional meaning as crime, given that there is no apparent reasoning, either in the Travaux Preparatoires or the Rome Statute, as to why the requirements for establishing territorial jurisdiction, whether the crime occurs on the territory of a state party or on a registered vessel or aircraft of a state party, would differ. And as such, that conduct carries the same functional meaning of crime, and that at least a constituent element of the crime must occur in their territory. Your Honours, the crime alleged, that of Article 8.2b3, intentionally directing attacks against humanitarian assistance or peacekeeping missions, does not require any effects. It is a crime that is complete upon the directing of the attack, and as such, the prosecution cannot show that any constituent or actus reus elements of the crime occurred in the territory of a state party. Now, notably, the prosecution is likely to attempt to rely on the objective territoriality principle and allege that the humanitarian character of this crime means that the impediment to the delivery of aid in the state of Essex in some way establishes a requisite territorial nexus. To that, the government would say that an interpretation of the elements of crimes, which expressly do not put forth that the delivery of aid is required or that the crime is any way related to the delivery of aid, is contrary to Article 22(2) of the Rome Statute, which mandates that Your Honours interpret the elements of crime strictly without analogy in favour of the defendant. And thus, your interpretation of this crime must relate solely to protection of the humanitarian installations, materials, units or vehicles in which this crime affords the protection to. And as such, that this court cannot determine that the principle of objective territoriality allows for this court to establish jurisdiction. Your Honours, notably, the prosecution may also rely on the effects doctrine in order to establish territorial jurisdiction. Now, counsel for the defence has correctly identified that the effects doctrine is not an applicable principle of law before this court. Now, firstly, this is because such an application of the principle would be contrary to the express wording of Article 12(2)(a), whereas conduct carries the same functional meaning as crime. Second, Your Honours, and in any event, the drafters of the statute, as put by the court in the Bangladesh and Myanmar situation, expressly foresaw that only customary international law would be applied as a matter of interpretation before this court. And as such, if the effects doctrine were to apply as a matter of interpretation of conduct in question, it must be shown to be a customary principle of international law. Your Honours, it was noted by the court in Bangladesh and Myanmar that the principle of the effects doctrine is applied scarcely in international law. They expressly noted that it occurs only in antitrust and competition law, and as such, it does not meet the threshold of customary law and cannot be applied by Your Honours as a matter of interpretation. Your Honours, I now turn to my second submission, which pertains to the head of state immunity of President Sirax. It is particularly the government's submission that the pre-trial chamber erred in finding that this court maintains the requisite jurisdiction to prosecute an incumbent head of state of a non-state party. Your Honours, it is not disputed that President Sirax is the incumbent head of state of the state of Marine. She was re-elected as president on the 2nd of November 2024 for another 4-year term. As such, she is awarded with the immunity rationale personae, customary immunity in which allows for full and complete inviolability from any act that would hinder the performance of that individual's duties. And that was put forth by the International Court of Justice in the arrest warrant case, whereas, importantly, Judges Higgins, Coomans and McGenthal, in their joint separate opinion, noted that the immunity belongs to the state. It attaches to the office. And as such, this particular customary immunity can only be waived by the state. Your Honours, the Government of Marine has expressly refused to waive this immunity. It has not ratified the Rome Statute in Article 27, and it has not waived its immunity under Article 98. Nor is there a United Nations Security Council referral, as noted by Counsel for the Defence, in which would warrant this court erga omnes jurisdiction over the matter. As such, Your Honours, pursuant to Article 34 of the Vienna Convention on the Law of Treaties, Article 27, which purports to remove the immunities of President Sirax before this court, cannot be applied to Marine as a non-state party. Your Honours, the Government of Marine understands, however, that there is an exception to this general principle, namely under Article 38 of the Vienna Convention on the Law of Treaties, whereas if it is shown by the prosecution that Article 27 is an embodiment of customary law, it may be applied upon a non-state party. Your Honours, the Government would however note that this court's jurisprudence, and likely the prosecution, will rely on an inverted and incorrect legal burden. Particularly, the appeals chamber in al-Bashir simply found that there is neither state practice nor opinio juris supporting head of state immunity before an international court such as the ICC. The Government would submit that this is the incorrect test. Given that there is an established customary rule of head of state immunity for complete and full inviolability from any act that would hinder the performance of President Sirax's duty, this court must show that Article 27 is an embodiment of a customary principle of law that allows for the removal of head of state immunity. Now, this follows the reasoning of the International Court of Justice in the nuclear weapons advisory opinion, whereas the court noted that the absence of a customary rule permitting nuclear weapons was not sufficient to establish a customary rule prohibiting them. As such, Your Honours, it must be shown that there is a customary rule in international law which allows for the removal of head of state immunity before the ICC. Your Honours, the government notes that the prosecution is likely to rely on obiter dictum found in the arrest warrant case, whereas the court noted that there are certain exceptions to immunity rationale personae, particularly that international courts may remove the immunity where they have jurisdiction. Notably, the court went on to note that such courts include the future ICC. Your Honours, the government submits that the correct interpretation of this obiter dictum is that this court may displace with the customary immunity only where they have the correct jurisdictional tools, whether that be by express consent to Article 27 or erga omnes jurisdiction derived from the United Nations Security Council. The courts that were mentioned in that obiter dictum included the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, and the Special Court of Sierra Leone, all courts in which retain erga omnes character from the United Nations Security Council. The government of Marine does not contest that whereas this court has a United Nations Security Council, it may remove the head of state immunity of a non-state party. But here, Your Honours, given that there is not a United Nations Security Council referral, there is no requisite jurisdiction for this court to remove such an immunity. Your Honours can also look to state practice to determine the absence of a customary rule allowing for the removal of immunities. For example, Your Honours, before this court, no ICC arrest warrant against a sitting head of state of a non-state party has ever been executed. President Putin, for example, travelled to Kyrgyzstan, Kazakhstan, Vietnam, Mexico, and Mongolia, who all refused to arrest him on the basis that he's accustomed to immunity rationale personae. Your Honours can also look to the recent agreement between the Council of Europe and Ukraine to establish a special tribunal to prosecute crimes of aggression in Ukraine. That agreement included a provision in Article 23, whereas the court expressly noted that they could not prosecute an incumbent head of state. They stated that whereas an indictment for an incumbent head of state is released by the court, they must wait to prosecute or arrest the individual until they cease to be the head of state. Your Honours, the government of Marine does not contest that immunity rationale materiae, the immunity that exists whereas the individual ceases to be a head of state or relinquishes their position in office, allows for this court to prosecute the individual for breaches of crimes against humanity and war crimes. But in this particular instance, President Sirax is the incumbent head of state of the state of Marine. And as such, any attempt to remove this immunity, an immunity which exists not only to ensure the equality of states, but exists to ensure that diplomacy at the highest level can continue to function, would pose a significant threat to the peace and stability of international relations and mean that states at the highest level cannot engage in functional diplomacy. Your Honours, I'll now turn to my third and final submission, which pertains to the irregular rendition. The government submits that the pre-trial chamber erred in finding that this court should maintain jurisdiction to prosecute the defendant, irrespective of the illegal means of rendition. Your Honours, counsel for the defence has submitted that there is no customary principle of male captus bene detentis. The government would submit that we need not put our case that high. This court's jurisprudence in the case of Labunga has expressly noted that this court can refrain from exercising jurisdiction in certain cases, such as whereas there is an abusive process, particularly where the abuse includes the bringing of the accused to justice by illegal or devious means. Your Honours, the standard that was put forth by the court is that such a rendition must be odious or repugnant to the administration of justice. The government submits that the facts and the circumstances that have occurred here meet that threshold. pursuant to paragraph 20 of the case and clarifications, whilst travelling on her presidential jet, President Sirax was forcibly removed and anaesthetised by Dothraki security personnel. Importantly, this jet constitutes the sovereign territory of the state of Marine. And this is pursuant to the customary flag state principle, which is enshrined in the Rome Statute at Article 12.2a. This means, Your Honours, that this rendition not only violated the personal rights and liberties of the defendant, not only violated the principles outlined for extradition in the Rome Statute, including Articles 59.1, 59.2, 89 and 91, but most importantly, violated the territorial and political sovereignty of the state of Marine. Your Honours, it is further noted that such conduct is a breach of a jus cogens principle, specifically the jus cogens principle which prohibits the use of force against the territorial integrity of another state. This is the principle in which no derogation is permitted. Your Honours, the Rome Statute's preamble expressly puts forth that states shall refrain from the use of threat or force against the territorial integrity or political independence of any other state. It further notes that noting this, the statute does not authorise the intervention in the internal affairs of another state. Your Honours, not only is this conduct effectively amounting to a forced change in governments for the state of Marine, but this conduct is facilitating the erosion of the rule of law in the international community. As noted by counsel for the defence, the Lubunga decision expressly put forth that this court stated the interest of the world community to put persons accused of the most heinous crimes against humanity on trial, as great as it is outweighed by the need to sustain the efficacy of the judicial process as the potent agent of justice. This court cannot blindly pursue its role in ending impunity at the stake of facilitating the erosion of the rule of law, as well as principles of sovereignty that in the government's submission serve a much broader purpose in ensuring and mitigating acts of aggressions between states, and ensuring that suffering, and not only impunity, is put to an end, and ensuring that peace on this earth can continue. Your Honours, if there are no further questions, that concludes submissions on behalf of the government.
Thank you, counsel. Now it's turn for the prosecution.
Mr. President, members of the court, a very warm good morning. If it may please this honorable court, I am Aisha Khan, and I shall be representing the Office of the Prosecution in the present matter. As your honours are aware, on 31st October 2024, an international armed conflict arose between the states of Marine and Essex, during which the defendant ordered a naval blockade that knowingly attacked an essential shipment of humanitarian aid, preventing it from reaching children in Essex, even as the WHO publicly warned that thousands of children faced permanent disfigurement. Your Honours, these are not abstract violations. These are calculated decisions taken deliberately from the highest office in Marine in full awareness of their humanitarian consequences. In this regard, the prosecution requests this court to uphold the decision given by the pre-trial chamber and to dismiss the defense's appeal in its entirety. I shall be dealing with three pertinent issues before this court today. First, that the defendant ordered a war crime within the jurisdiction of the ICC. Second, that the defendant can be tried by the ICC notwithstanding her status as the sitting head of state of Marine. And third, that the case must not be dismissed because of the irregular means of her rendition. With that, Your Honours, I shall proceed to issue 1, proving that the defendant ordered a war crime within the jurisdiction of this court. I shall demonstrate 3 main propositions. First, that the court has territorial jurisdiction in this case. Second, that the actus reus and mens rea of the war crime under Article 82b3 are fulfilled. And third, that the defendant ordered the commission of the war crime under Article 25(3)b of the Rome Statute. Your Honours, under our first submission, it is submitted that the court has territorial jurisdiction in this case. Your Honours, the defence and government have both argued that the alleged conduct in this case occurred just outside the territorial waters of ICC, and thus the court lacks jurisdiction. However, it is the case of the prosecution that this court retains jurisdiction over the matter under the effects doctrine. Your Honours, this very court in the case of Bangladesh, Myanmar in 2019, in paragraph 56, has accepted and acknowledged the application of the effects doctrine, defining it as: states may assert territorial jurisdiction if the crime takes place outside the state's territory but produces effects within it. Your Honours, the government has further argued that the Bangladesh-Myanmar case qualifies this application by requiring a constituent element of the crime or the actus reus of the conduct to have occurred within the state that is exercising jurisdiction. However, the prosecution would like to clarify in this regard that when referring to this requirement of actus reus in paragraph 61, the court in the Bangladesh-Myanmar judgment is referring to the objective territoriality principle, which was eventually applied in the ratio of the decision, and not the effects doctrine, which is what the prosecution invokes in this case. It cites the Bangladesh-Myanmar judgment not to compare the facts between the two cases, but simply to recognize that the ICC, in a judgment before this, has in fact acknowledged the existence of the effects doctrine and its application in international criminal law. Therefore, the government cannot argue that it is simply restricted to antitrust or competition-based matters. Further, Your Honour, it is submitted that in this case, we are not inflating the concepts of conduct, consequence, or crime. Instead, we are simply reading the effects doctrine with the existing provision of Article 12(2)a on territorial jurisdiction within the Rome Statute, quite similarly to the way it has been acknowledged in the Bangladesh-Myanmar case as being read with the same provision. Accordingly, Your Honours, applying the effects doctrine in this case, the impediment of humanitarian aid was the effect of the alleged conduct of firing the tracer rounds, which occurred entirely within the state of ICC, which has accepted jurisdiction in this case. Therefore, Your Honours, territorial jurisdiction is established. Under the second sub-issue, I shall prove that the actus reus of the war crime and mens rea are fulfilled in this case. Importantly, Your Honours, under Article 61, subclause 7 of the Rome Statute, at this stage of proceedings, the pre-trial chamber must simply determine whether there is sufficient evidence to establish substantial grounds to believe that the person committed the crimes charged. The chamber need not be convinced beyond a reasonable doubt. With respect to the material elements, Article 82b3 requires 3 main things. First, that the perpetrator directed an attack. Second, that the object of the attack was a humanitarian assistance mission. And third, that the mission was entitled to the protection given to a civilian object under international humanitarian law. Your Honours, under the first element, it is submitted that the element of attack is satisfied in this case. Under Article 49 of Additional Protocol 1, an attack consists of acts of violence against the adversary, which is a definition which has been utilized by the Defence Counsel before this court. Importantly, Your Honour, as highlighted in the case of Sese before the Special Court of Sierra Leone in 2005, an attack does not require actual physical damage or casualties. The same court further recognized that an attack includes a forceful interference which endangers the person or impinges upon their liberty. In this case, Your Honors, the firing of the tracer rounds across the bow of the Dothraki ship constituted a forceful interference into its liberty, preventing it from crossing the blockade, forcing it to reverse course and return to Dothraki. Your Honors, the defense has argued that this definition given by the Sese judgment is not applicable in this case, as it is a judgment of the SCSL and not the ICC. However, the prosecution seeks to clarify that the definition applied by the court in the Sese judgment is that of Additional Protocol 1, being the act of violence against adversaries, which is the same definition that has been employed by the ICC in the Taganda case, as has been cited by the defense. Further, Your Honor, we cite the judgment of Sese before the SCSL in particular simply because it deals with a similar war crime of attacking a humanitarian assistance mission, the war crime of which has not been dealt with by the ICC before. However, the definition of attack remains symmetric across them, which is the same as the Additional Protocol 1, binding on all parties in this case. Further, Your Honors, with respect to humanitarian assistance, we would simply like to clarify that the ICJ in the Nicaragua case has found that such assistance may be provided by individual states, and in this case, the sole purpose of the Dothraki vessel was the provision of essential humanitarian aid. Further, Your Honors, this very court in the decision of Abu Garda has held that the phrase, in accordance with the Charter of the UN, does not require a special mission established by the UN, but covers all missions whose objectives are otherwise overseen by the UN Charter. Finally, Your Honor, it is submitted that in this case, the vehicle was indeed entitled to the protection given to civilian objects simply because, under international humanitarian law, civilian objects are protected until and unless they are used for military purposes. In case of any doubt as to whether a civilian object is being used to make an effective contribution to military action, it shall be presumed not to be so used. Therefore, the object remains protected. Your Honors, if I may proceed to my final sub-issue under Issue 1, I shall prove that the defendant ordered the war crime under Article 25(3)(b) of the Rome Statute. The actus reus under Article 25(3)(b) requires two main things. First, the accused held a position of authority over the perpetrators, which is satisfied in this case, as President Cyrax was the President of Marine and Commander-in-Chief of the Naval Forces. The second element requires that the accused instructs another person to engage in the act, which has a direct and substantial effect on the eventual commission of the crime. In this case, Your Honors, the defendant ordered the Marine Navy to enforce a naval blockade, which led them to using all means, including the firing of tracer rounds, to enforce the blockade and carry out her instructions. Therefore, the actus reus is satisfied. Under the mens rea element of Article 25(3)(b), that is the intention of President Cyrax to impede the humanitarian aid, Your Honors, if I may guide you to paragraph 13 of the fact sheet, the fourth line for the bottom, I shall read it out for the court. It reads, "The Director General of WHO called on Marine to lift its blockade, which he said would otherwise result in the disfigurement of hundreds of thousands of ISIS children, as ISIS has no stocks of azithromycin or any other medicine that could effectively treat yours." But President Cyrax replied the next day that she would not do so until ISIS rescinded its anti-Iraq decrees. Your Honors, these facts clearly indicate that the President of Marine was clearly aware of the humanitarian needs and consequences within ISIS and nonetheless took the conscious decision to proceed and maintain the blockade, fully aware that it was in fact also blockading humanitarian assistance and not simply trade. With that, Your Honors, if it may please the Honorable Court, I shall proceed to my second issue. My second submission is that the defendant can be tried by this court notwithstanding her status as the sitting head of state of Marine. Your Honors, the prosecution makes one main submission in this regard, that Article 27(2) of the Rome Statute applies to the defendant in this case. Your Honors, the defense and the government have both argued that Article 27 does not apply to non-party states such as Marine. However, the prosecution submits that this is incorrect, as Article 27 has crystallized into customary international law and is therefore applicable to all states, including that of Marine. Your Honors, in the case of Jordan appeals, this very court in paragraph 13 of 2019 categorically observed that Article 27 of the Rome Statute has become declaratory of customary international law. Further, Your Honors, the ICC has very recently issued arrest warrants against both President Vladimir Putin and Prime Minister Benjamin Netanyahu, both of whom are incumbent heads of non-party states, similarly to President Marine in our case. Your Honors, the government has argued that the arrest warrants against both Mr. Putin and Netanyahu are yet to be executed. However, the ICJ in the case of arrest warrants has clarified that the mere issuance of an arrest warrant is a disregard for head of state immunity, and therefore the mere issuance of arrest warrants against these leaders is a clear position of a disregard of head of state immunity before international courts by the ICC. Further, Your Honors, multiple states, including the Netherlands, Chile, Colombia, Turkey, and Iceland, have publicly affirmed their support for these arrest warrants, strengthening the customary international law backing, which was already clarified in the Jordan appeals decision. Finally, Your Honors, the ICC, in cases such as Malawi and al-Bashir, has further affirmed that head of state immunity does not operate before international courts such as the ICC, which operate through a vertical relationship with states and carry an international mandate dealing with serious crimes of international concern. Therefore, Your Honor, there is no head of state immunity that can affect jurisdiction in this case, and President Marine can very validly be tried by this court. With that, Your Honors, if it may please the Honorable Court, I shall proceed to my final submissions under Issue 3. I shall be arguing that the pretrial chamber correctly held that the case must not be dismissed because of the irregular means of the rendition of the defendant in this case. I shall make two broad submissions in this regard. First, that the doctrine of male captis benedictentis has been applied before international criminal tribunals. And secondly, in any event, dismissal of jurisdiction in its entirety is simply not the remedy that has been envisaged under the Rome Statute for an illegal rendition, and in any case, the standard of dismissal has not been met. Your Honors, under the first sub-issue, it is submitted that international jurisprudence, including the cases of Nikolic, Ptolemir, and Karadzic before the ICTY, and Lubanga appeals before the ICC, have consistently affirmed that once the accused is before a competent international tribunal, their manner of arrest will not bar jurisdiction. Your Honors, the underlying principle is simple. Irregular rendition does not divest this court of its jurisdiction, and the principle of male captis benedictentis is applicable in this case. Further, Your Honor, the prosecution importantly submits that the Rome Statute simply does not provide for dismissal of jurisdiction of this court as a remedy for an illegal rendition under the Rome Statute, and such a remedy simply cannot be sought by the defense and the government. Your Honors, in this respect, the prosecution submits that the grounds for challenging jurisdiction of this court are limited under Articles 17 and 19 of the Rome Statute. Importing extraneous grounds such as abuse of process would be contrary to the scheme laid out in the Rome Statute, and this has been acknowledged by this court in the Lubanga appeals decision in paragraph 34, where they have clarified that the abuse of process doctrine simply cannot apply before the ICC, as the Rome Statute is already exhaustive on the means of dismissal and arrest. Therefore, the defense and government simply cannot rely on this doctrine to support their case. Further, Your Honors, even for an illegal arrest, the right to release is simply not envisaged as a remedy under Article 55(1)(d) of the Rome Statute, with alternative remedies such as compensation or reduced sentence being provided instead, which can certainly be provided to the defendant in this case, depending on the factual determination by this court. Further, Your Honor, with respect to our last submission under Issue 3, it is highlighted that the standard of dismissal has not been met in this case, as firstly, there has been no concerted action by the prosecution, and secondly, the standard of serious or egregious violation has not been met. Your Honors, the defense has argued that attribution to the prosecution is not relevant. However, both the cases of Nikolic before the ICTY and Lubanga appeals before the ICC have clarified that the involvement of no arrest was carried out entirely by Dothraki agents who have subsequently and explicitly claimed full credit of the capture. Further, once the defendant was surrendered at The Hague, the prosecution was no longer exercising discretion. It was fulfilling a binding legal obligation under Article 60, subclause 5 of the Rome Statute. Finally, there has been no serious or egregious violation in this case. Simply because the defendant arrived at The Hague unharmed, there was no substantial delay between the arrest and transfer, and crucially, there is no allegation of any misconduct by the prosecution from the moment she has entered custody. Her fair trial rights have been respected, and anything that occurred prior to that is simply not attributable to the prosecution. In any case, there is simply no remedy for dismissal envisaged under the Rome Statute that can be argued for by the defense and government. In conclusion, Your Honors, the law is clear, the facts are clear, and the evidence is sufficient. We request this court to uphold the pre-trial chamber's findings in this matter and to reject the defense's appeal in its entirety, simply to prevent impunity and ensure accountability for the most serious crimes of international court concerned before this court. That concludes the prosecution's submissions on this matter. It has been an honor arguing before this court. Thank you.
Thank you, Counsel. I note as a presiding judge that all parties and participants, they are abiding by time limit. I also note very effective work of the registry officers by showing signs to guide the participants through these time limits. Now we proceed further because important issues have been raised and they need to be discussed and dealt with. So let me make clear, I will now invite the bench to ask questions, and for the sake for the sake of ensuring equality, strictly equality to all, the fairness to all parties and participants, the same question would be asked to all parties. So we'll have questions to all parties, so each of you could respond. For the response, you will have 15 minutes, each of you, and we'll proceed in the same order, starting with the counsel for defendant. If it is clear, may we proceed in that way? So, counsel for the defendant.
Certainly.
You may start, please. But no, first questions.
Certainly, I would be happy to assist Your Honors in
Yes.
any questions before turning to my rebuttal submission.
Please.
Thank you very much. I have one question in relation to the second item in the agenda, and it concerns some recent jurisprudence of this court in the Ukraine situation, where some of the arguments that have been made have been discussed, in particular Article 27, the obligations that Article 27 imposes on states parties as well as the states that have accepted the jurisdiction of the court. And what does this mean for heads of state, of non-state parties, assuming in this case, I understand that the argument of both the defendant and the government is that this court does not have territorial jurisdiction. For the purpose of this question, if you could assume that the court has territorial jurisdiction, I would be grateful to hear your response in this regard. Thank you.
Certainly. Well, Your Honor may be referring to the situation in Ukraine line of cases, where we note in this court's finding on the non-compliance of Mongolia that the court did say that for state parties and for parties who have accepted this court's jurisdiction through a declaration, that their heads of states do not enjoy immunity. But that is different from the present case. If I may quote, in fact, paragraph 19 of the Situation in Ukraine-Mongolia decision, the Chamber, and I quote, notes that the issue under consideration is neither whether there exists for heads of states under customary international law an immunity vis an international court, but more importantly, nor whether non-state parties are bound by the provisions of the statute. So in other words, how we read the Mongolia decision is that only state parties or accepting states lose the immunities of their heads of states. But because the government we represent has not consented to this court's jurisdiction, then that finding does not apply to the present case. I hope that assists Your Honor, Judge Bropil. If there are any further questions, I would be happy to assist.
Manner that other parties and participants could
Certainly.
respond to the same question.
Certainly.
Counsel, please.
Could you just repeat the question, please, Your Honour?
Yes. My question concerns some recent jurisprudence from the court in the Ukraine situation, where the chamber was commenting in particular on the interpretation of Article 27 and what Article 27 may or may not mean for heads of states of non-state parties or states that have not accepted the jurisdiction of the court. And I understand your position is that this court does not have territorial jurisdiction. Please assume that we do have territorial jurisdiction for the purposes of answering the question. Thank you.
Certainly, Your Honour. I believe Your Honour is referring to the recent decision that was pronounced a bit over a week ago in the situation in Ukraine, specifically the response to the submissions of a state party under Article 97 of the Rome Statute. Now, the government does not contest or deny, in fact, that that decision did state that Article 27 applies and removes the head of state immunity, in effect, of anyone, irrespective of the type of their official capacity and irrespective of whether they are a state party. However, the government would still submit that this court and its line of reasoning that follows the Al-Bashir Appeals Chamber decision in the Jordan referral is materially incorrect in that it errs in law. Simply finding that this court has an international character is insufficient to displace the customary immunity that exists. This court's line of reasoning, specifically in the Mongolian non-compliance decision, which stems from the situation in the state of Ukraine, simply puts forth that the only rationale for head of state immunity is that of the equality of states, and such that this court, as an international and neutral arbiter of justice, then displaces that rationale. And the government does not contest that the equality of states is displaced, or rather the rationale for the head of state immunity, being equality of states, is displaced before this court as an international court. However, what is not displaced is the rationale that head of state immunity, and immunity rationale personae, exists to ensure that diplomacy between states can continue to function, to ensure that the internal political affairs of a sovereign state cannot be interfered with, whether that is by a state on a horizontal level or by this court, and ensures that states can continue to peacefully coexist, to peacefully engage in constructive diplomacy, and ultimately to create the best possible international relations that can be afforded to this earth. Your Honours, The court in that decision also refers to the reasoning of the al-Bashir Appeals Chamber, in whereas they simply note that there is an absence of a customary rule showing the applicability of head of state immunity before an international court such as the ICC. We would first note that the ICC does not have the character of other international courts such as the International Criminal Tribunals for the former Yugoslavia and Rwanda, as those courts are created under a Chapter 7 mandate of the United Nations, and as such, they have erga omnes character. This court is an inter partes treaty which relies on the acceptance and ratification of its provisions by sovereign states. It exercises the sovereign jurisdiction of its states, and thus, as pointed out by Counsel for Defence in her primary submissions, pursuant to the principle of nemo dat quod non habet, given that those state parties cannot prosecute a head of state on a horizontal level, through the principles of complementarity in which this court exercises jurisdiction, this court cannot then receive such a right to prosecute a head of state themselves. Finally, Your Honours, as noted in my primary submissions, the legal burden has been inverted by the court in the al-Bashir's chamber, simply because there is an absence of a customary rule showing the application of head of state immunity before an international court is insufficient to show that there is a customary rule, as required by Article 38 of the Vienna Convention on the Law of Treaties, to displace the customary rule that exists, a rule that prohibits any interference in the internal functioning of a state. Your Honours, to that end, it must simply be shown by the prosecution that there is requisite opinio juris and state practice to show the applicability of a customary rule, one that removes head of state immunity of non-state parties, before this court. That cannot be shown. As noted by counsel for the prosecution, there are some states in which support the notion that head of state immunity does not pose a bar to prosecution before international courts such as the ICC. However, as noted by the International Court of Justice in the North Sea Continental Shelf case, for there to be the requisite state practice, the law must be virtually uniform, and it must be settled law. This is not settled law. I note that the entirety of the African Union disputed the decision that was rendered in the al-Bashir Appeals Chamber. I note that states continually refuse to exercise the arrest warrants of this court on the grounds that this court maintains, or rather the heads of states, maintain immunity ratione personae. And as such, this court, as a court that operates through the principles of complementarity and requires acceptance of the Rome Statute, cannot go against the wishes of the international community in which, in its own jurisprudence, it puts forth, allows it to remove head of state immunity. Your Honours, if that answers your question, that concludes the government's submission.
Thank you, counsel. The counsel for prosecution, you have the floor.
Good morning once again, Your Honours. The prosecution would like to respond to the question posed by Your Honour with a two-pronged response. The first being that Your Honour has questioned the counsels on the situation in Ukraine and the more recent jurisprudence on the same. While the prosecution agrees that the Mongolia cooperation decision was specifically with respect to Mongolia as a state party, as has been cited by the defense in their response, we highlight that the very issuance of an arrest warrant for President Vladimir Putin as being individually criminally responsible for the crimes committed within the territory in the situation of Ukraine, despite the state of Russia not being a state party to the Rome Statute, is sufficient to show that the International Criminal Court has disregarded his personal immunity as an incumbent head of state of a non-party, which is entirely symmetric to the facts in this case and that of President Dragonas Syrex as the President of Marine. Further, Your Honours, on our second prong, we would wish to engage with the government's responses with respect to Jordan appeals not being applicable as a source of law before this court. However, we highlight that under Article 21(3) of the Rome Statute, Jordan appeals qualifies as a case law precedent which holds persuasive value over this court. Further, Your Honours, it decided that Article 27 is customary international law on the basis of relevant grounds such as the object and purpose of the Rome Statute, a conflict avoidance-based reading between Article 27 and 98, and on the grounds that the ICC carries an international mandate of all its state parties and of the world at large. On our final rebuttal and response, Your Honour, we would simply like to highlight that there is indeed state practice and opinio juris to support the position of Article 27.2 as customary international law. As highlighted in our primary submissions, states such as Netherlands, Chile, Colombia, Turkey, and Iceland have indeed publicly affirmed their support for the arrest warrants issued by the ICC. And finally, the case law of Jordan appeals falling under Article 21, subclause 3 of the Rome Statute shall be placed at a higher hierarchy in source of law as opposed to state practice that the government may cite in this regard, which falls under Article 21, 1b or c of the Rome Statute, placed at a lower hierarchy than 12.2, which is 21.2, which is read with Article 21.1a. With that, Your Honours, we shall conclude our answers to this question. Thank you.
Thank you, Counsel. Judge Kortmans, I will invite you to, if you have questions to the parties and participants.
Thank you. Yes, I have a question about the government of Marine standing to make submissions before the court. So I'll first ask my question to the government, and then the other parties will have an opportunity to respond. So first, could you explain why you decided to rely on Article 19.2c of the statute rather than 19.2b? And second, how can Marine be a state from which acceptance of jurisdiction is required when it has not accepted the court's jurisdiction, and the court may already exercise jurisdiction based on the declaration made by the state of ISIS? Thank you.
Your Honour, I'll answer your question in two parts. Firstly, the Government of Marine relies on Article 19.2c on the basis that its acceptance of jurisdiction is required. We note that the government has yet to accept this court's jurisdiction under Article 12.3 as an ad hoc exception, which would allow for this court to exercise jurisdiction over the crimes which have occurred prior to this decision. Your Honours, given that the territorial jurisdiction, the jurisdiction of this court to prosecute a head of state, and the jurisdiction this court, or the question of whether this court should retain jurisdiction to prosecute the defendant irrespective of the irregular means of rendition, can all be remedied by ascension by the Government of Marine to the Rome Statute. The Government of Marine should have standing under Article 19.2c to contest and dispute this court's current means of jurisdiction, particularly that of territoriality, particularly that they attempt to apply Article 27 upon the state of Marine irrespective of their non-consent, and particularly because this court is attempting to apply jurisdiction irrespective of the egregious breaches of sovereignty that have occurred to the state of Marine. Your Honours, to answer the second part of your question, Article 19.2c allows standing, or rather Article 19.2b allows standing for a state which has jurisdiction over a case on the ground that it is investigating or prosecuting the case, or has investigated or prosecuted the case. Your Honours, there is nothing in the facts which points to the fact that Marine has initiated investigations into the case. As such, Your Honours, the more concrete ground for standing before this court today is that of Article 19.2c, as it is obvious that this court requires acceptance of the Rome Statute by the state of Marine, which would allow for this court to exercise jurisdiction through the nationality limb under Article 12.2b. It would also allow for this court to waive the customary right to immunity that is afforded to President Dragonis Sirax through ascension to Article 27. And it would also allow for this court to exercise jurisdiction irrespective of the breach of sovereignty, as the state of Marine can simply waive the breach of sovereignty as occurred in the case of Eichmann with the breaches of sovereignty to the state of Argentina. If there's no further questions, Your Honours. Thank you.
Apologies, Your Honor. I think your mic might not be on, so I did not hear that direction.
I would invite the defense to comment, to respond on the same question, and then the counsel for the prosecutor will take the floor.
Judge Korkmaz, I believe there were two nuances to your question. The first being why Article 19(2)(c is the provision for this, for the government standing. The second being why it appears to accept the court's jurisdiction, but yet again challenge it. Well, on the first point, if I may assist Your Honor with paragraph 21 of the facts, which I will quote. The government of Marine has issued a diplomatic note, and it has requested to participate in the proceedings, but it has also made clear in the last line of paragraph 21 that Marine will not waive the international immunity of President Cyrex. This is why we believe the government has not sought to raise Article 19(2)(b as its basis, since that requires investigations by that state. On the second nuance pointed out by Your Honor, we recognize that states can bring challenges to jurisdiction and accept this court's jurisdiction for the limited purpose of doing so. This is the doctrine of competence, which underpins this court's structural process. And so likewise, paragraph 25 clarifies that the government seeks to challenge the jurisdiction of this court for which it has accepted for a limited time to participate. I hope that answers your question. Thank you, Your Honor.
Thank you. The counsel for the prosecution, please.
Your Honours, with respect to the right to participate for Marine in these proceedings, the prosecution would simply like to highlight that under Article 19(2)(c of the Rome Statute, under which the state of Marine is seeking to participate in these proceedings, it requires that a state from which acceptance of jurisdiction is required under Article 12. It is submitted in this regard, Your Honours, that this requirement is simply not fulfilled in this case, as we do not require Marine to accept jurisdiction, as the prosecution has already established territorial jurisdiction through the state of ACIS, through their declaration under Article 12(3) of the Rome Statute in particular, and has established territorial jurisdiction under Article 12(2)(a), therefore not requiring Marine to accept jurisdiction in this case. However, Your Honours, even if the court was to decide to allow Marine to proceed and participate in these proceedings, the prosecution would simply aim to engage with and rebut their substantive arguments made before this court, similarly to the defense counsel. That shall be a response. Thank you.
Thank you. I have the question myself for all parties. It's about irregular rendition and male captus pene detentus. To my knowledge, I would say that ICC, through its jurisprudence, never explicitly endorsed male captus pene detentus in a permissive manner. So what does it say for you? How silence of the ICC can be interpreted with respect to the assertion that it is customary law? Is it about endorsement, acquiescence by the actors such as ICC of the customary rule, or is it the opposite? So let's go in a sequence. The defense.
I believe, Mr. President, you are drawing 2 points out on the effect of silence. Now, the first point on whether silence amounts to endorsement is exactly why we stand here today. Now, earlier, I have already addressed that attribution is not a requirement according to the Bagbo decision. And so if this court continues to proceed with this case, despite having full knowledge of what my client has gone through, then this silence does amount to endorsement of such illegal conduct. But I note that you also had a query about silence with regard to the Malay captors doctrine. We would suggest that the court's silence on this doctrine does not necessarily amount to endorsement or rejection of it. But then the question for this court is how to reconcile this doctrine with other principles in the Rome Statute. And we say to this that because Article 21(3) of the Rome Statute requires this court to apply the law in accordance with human rights laws, then this silence, read with this provision, actually shows that such a doctrine cannot be accepted by this court, contrary to the prosecution submissions. Thank you.
Thank you. The counsel for the government, please proceed.
Your Honours, to answer the first part of your question, the mere silence of this court, specifically in the Lubanga Appeals Chamber decision, which had the most intense discussion as to this court's ability to exercise jurisdiction in cases of irregular treatment or rendition, does not necessarily amount to Malay captus benedentis being evidence of custom. However, what we would submit that as a customary matter, as noted by counsel for the defence, this court has competence de la competence. That is, that Your Honours have the discretion to determine whether or not to exercise jurisdiction. Now, specifically in the Lubanga appeal at paragraph 24, the court noted that the application in and of itself, given that the Rome Statute contains no provision for a stay or dismissal of proceedings, is a sui generis application, that the court is exercising its inherent power to stop judicial proceedings where it is just to do so. As such, Your Honours, this effectively requires a balancing act. Your Honours must consider the egregiousness, perhaps, of the alleged conduct, the egregiousness of the extradition, as well as the principles endowed in the Rome Statute. The government would submit that the principles in the Rome Statute not only require that Your Honours put an end to impunity. It does not say that Your Honours need to put an end to impunity at all costs. It specifically states in the preamble that this court should not authorise states to intervene in the sovereign affairs of another state. And as a whole, this court's role in international justice is not merely to put an end to impunity. This court has a much larger role. Its role is to support the rule of law. The government submits that in allowing for such an extradition to occur on the sovereign territory of the state of Marine, irrespective of the rights of the defendant and irrespective of the rules of extradition, would mean that this court is facilitating in the erosion of the rule of law in international law. This court cannot stand for such a principle. After all, its role in the international community is to be the arbiter of justice. Your Honours, to allow for jurisdiction in this matter would signal to states that they need not consider the human rights of an individual when rendering them, that they need not comply with the extradition procedures explicitly outlined in the Rome Statute, and more importantly, that they need not comply with the principles of sovereignty that have governed international law since 1648. These principles, in our submission, serve a much more substantive purpose in ensuring that suffering is put to an end. That should be the ultimate purpose of this court. Your Honours, if there's no further questions.
Thank you. The prosecution, please.
Your Honours, we shall respond to this question in two main parts. The first relating to the possible acquiescence of this court in accepting the defendant after having come from an illegal rendition. Your Honours, with respect, we would once again like to quote the Nikolic decision before the ICTY which clearly recognized that being a mere recipient of the accused does not amount to acknowledging or accepting the conduct of those who have carried out the capture. Your Honor, in this case, the capture was carried out entirely by Dothraki agents, and all the accused fair trial rights have been respected by this court and the Office of the Prosecution in particular to the greatest extent possible in this case. With respect to the second part of the question, Your Honor, on male captis benedictentis, we would like to thank Your Honors for this question, as it allows the prosecution to clarify their position that we do not seek to argue that the male captis benedictentis principle is one of customary international law, but simply that it is a general principle of international law which is validly applicable before this court as a source of law under Article 21(1)b of the Rome Statute. To satisfy this, we have applied the cases of Nikolic, which has explicitly cited the male captis benedictentis principle, the Ptolemir and Karadzic cases similarly before the ICTY, and finally the Lubanga appeals decision before this court, which has once again reaffirmed jurisdiction despite an irregular rendition. Your Honours, the prosecution would like to highlight that there has been no tribunal internationally, including the ICTR, ICTY, SCSL, or even the ICC, which has ever in history dismissed jurisdiction in its entirety simply because of an irregular rendition. On our final point, Your Honour, the government has argued that the court may exercise its inherent powers in the interest of justice. However, we would like to urge and remind this court of the bigger question and the balancing act required in this case, simply because although there was an irregular rendition of the defendant which we in no way condone, we also would like to emphasize that she has been convicted of an alleged war crime of international concern before the ICC, and a dismissal of jurisdiction in its entirety here would lead to the creation of impunity and lack of accountability, which surely would not be in line with the objects and purpose that hold this court today. Therefore, Your Honour, we hope this balancing act can be kept in mind, as the defendant can surely be offered alternative remedies of compensation and reduced sentence, which are already provided under the Rome Statute. Further, if the government believes that the sovereignty of the state has been breached in its entirety by Dothraki agents, they may take up this case before the International Court of Justice as a dispute between parties of Dothraki and Marine, as it does not involve individual responsibility of the President. Thank you, Your Honours.
Thank you. We had quite interesting discussion and important for the bench. And I would invite bench, if you have other questions, please ask. I would ask one more question. As we know, under international law, not only use of force is prohibited, but also the threat of use of force. In that context, when we have a threat of using force and having posture of having a threat to threaten of use the force, can it still constitute the attack under the heading of Article 8 of war crimes? This is the question to all parties. Defense, you may start.
To clarify, the threat of a use of force would not arise to the level of an attack. Our authority for this comes from the SCSL Sase judgment at paragraph 1899. If I may quote for your honors, the chamber found that it was never the intention of international criminal law to criminalize threats towards peacekeepers. But I do recognize Mr. President's concern, which is under public international law, the threat of the use of force is sanctioned, as was held by the ICJ advisory opinion on nuclear weapons. But the use of force there is one of a much higher threshold in international law, not one on the attack question that we address today. So in other words, a threat for the purposes of today's proceedings is not an attack, but public international law has another conception in a different and more egregious context. Thank you.
Thank you. The counsel for the government. Just let me make one clarification that goes to the depth of my conviction as an ICC judge. That in the ICC, with respect to statute, we are not dealing separately with public international law and international criminal law. The statute is the duality. It's embodiment of both international treaty law and criminal law. So with that respect, with that having in mind, we are in one universe. So please, counsel for the government, please continue.
Your Honour, the government would agree with counsel for the defence in that the threat of a use of force is materially different to the use of force and as such should not be considered an attack by Your Honours. Your Honours could also look to customary naval procedure, which has been outlined by the United Nations Tribunal on the Law of the Sea in the case of MV Saiga at paragraph 156, where the court specifically notes that when verbal or audio-visual warnings fail, the firing of a round over the bow of a ship should be used to warn of oncoming violence. This, in and of itself, was the exact same acts that occurred in this situation. The firing of a tracer round across the bow of a vessel, purposely created to miss the vessel and utilised as a warning to ensure that the vessel did not continue. This was a threat of the use of force and a threat that the force, or rather a threat that force would pursue if the ship continued in its path. And as such, Your Honour should distinguish between force that actually causes damage and force that is merely a threat to cause damage. Your Honours can also look to the 2010 Fallujah incident, whereas the report of the Secretary-General panel of the United Nations specifically advised that Israel, before boarding the humanitarian vessels in which they were blockading, should have utilised a dissuasive use of force. Your Honours, this is in line with customary principles of wartime and both peace, in which individuals must use force at the latest means possible. And as such, Your Honour should distinguish between acts that are created and perpetrated with the means to mitigate the circumstances, rather than acts that are actually intended to cause harm. Thank you, Your Honours.
Thank you, the counsel for the prosecution. You have the floor.
Your Honours, with respect to your question on threats as an attack in this case, the prosecution firmly submits that a threat in this case amounts to an attack under the definition of the war crime under Article 8(2)(b)(3). Simply because, even if we were to accept the defense on the argument that the non-lethal tracer rounds were simply fired as a warning shot or as a compliance measure, they still do indeed fall within the test laid down by the Sese judgment that we have clarified and utilized in our preliminary submissions, that it is a forceful interference that impinged upon the liberty of the Dothraki vessel, even if it was intended only to act as a threat to prevent it from breaching the blockade. Your Honours, the defense has further argued that the Sese judgment in paragraph 1889 clarifies that threats merely do not amount to violence, but if I may read out the paragraph for your honors. It continues, while proof of actual physical injury or damage is not required, in our opinion, an act of violence requires a forceful interference which endangers the person or impinges on their liberty, which is clarified to have exceeded the threshold of a mere threat and therefore qualifies as an act of violence under Article 49(1) of the Additional Protocol 1. As a final notice, we would also like to contextualize the factual circumstances in which the blockade and the alleged attack occurred. Your Honours, the Dothraki cargo ship was a mere civilian vessel, unarmed and carrying humanitarian assistance, facing a naval blockade carried out by marine destroyers with a much stronger navy. For them, the mere firing of even warning shots was more than sufficient to force them to forcefully interfere with their liberty and force them to reverse course. As a final thought, Your Honour, we would like to clarify that we have utilized the definition of the attack as provided under Additional Protocol 1, as it is binding on all parties in this dispute, and as Mr. President highlighted, it is certainly read in consonance with the legal system provided under the Rome Statute and the laws applicable before the ICC as a broader jurisdiction which is qualified by both public international law and international criminal law. Thank you.
Thank you. To proceed further, so we'll have all the parties will have the time allocated 5 minutes for rebuttal to respond to the points raised by other parties. No, 5 minutes because we had discussion and then we reduce it further to have it expedited. Thank you, officer, for reminding. We'll proceed the way this court deems necessary. So 5 minutes. The defense will start from you.
Mr. President, Your Honours, 3 points in rebuttal. 2 on the first prayer, our final on the last prayer. Now, earlier, the prosecution relied on the effects doctrine and suggested that it has been endorsed by this court. The prosecution relies on the Bangladesh and Myanmar decision for such a proposition. But with respect, this is cited out of context. Rather, at paragraph 56 of the judgment, the chamber surveyed what states domestically practice in terms of criminal jurisdiction, the effects doctrine being one of them. But it did not go on further to endorse such a doctrine. Now, given the prosecution's heavy reliance on this case, we say that it is a legal misplacement, and that point should fail. Our second point of rebuttal remains on this first prayer, where we wish to add a different perspective to the government counsel's point. Now, earlier in his submissions, the government relied heavily on the idea that conduct, in his words, has the same meaning as crime. We wish to, with respect, depart from that position because we recognize that in the 2019 Bangladesh judgment, the court accepted that conduct encompasses a manner of behavior at paragraph 39, going more than a crime itself. But the court in Bangladesh still confined its approach to the elements of crimes. And so whilst we depart from the government, our stance still stands against the prosecution's case. Our final point of rebuttal goes towards the last prayer. Earlier, the prosecution suggested that the Lubanga decision rejected the abuse of process doctrine. Now, this is certainly the case in the pretrial chamber's decision, but the appeals chamber in Lubanga reversed that lower decision and accepted at paragraph 81 that an abuse of process serves as an additional guarantee to safeguard the accused's rights. For the foregoing conclusions, we ask this court to allow the appeal that we bring today and that all the prayers the prosecution makes should be dismissed to the contrary. Thank you, Your Honors. This concludes our case.
Thank you, the counsel for the government. You have the floor.
Mr. President, Your Honours, the government would like to advance 3 points of rebuttal. First, on territorial jurisdiction, second, on head of state immunity, and third, on the irregular rendition. Your Honours, with respect to territorial jurisdiction, as noted by counsel for the defence, counsel for the prosecution has alleged that the Bangladesh and Myanmar decision rendered by the third pre-trial chamber endorses the effects doctrine. This is an incorrect interpretation of that decision. The decision, specifically after undertaking the relevant analysis of the effects doctrine and other applicable doctrines of territoriality in international law, simply stated that there is opinio juris on the matter. They did not pronounce that it was customary. In fact, the court later pronounces that consequences can only be considered, this is at paragraph 61, whereas they are required for the crime to have been committed. Your Honours, any consequences, such as the deprivation of aid, which sparked the Yaws epidemic, are not required for this crime to have been committed, even whereas the attack may have occurred and the aid still got through. Your Honours could still find that the crime under Article 82b3 was committed. Your Honours, I further note that counsel for the defence has alleged to depart from the reasoning put forth by the government in that conduct in crime carries the same functional meaning, referring to paragraph 39, I believe, of the Bangladesh and Myanmar decision by the third pre-trial chamber. That interpretation would also be incorrect. Several paragraphs later, particularly at paragraph 48, the court expressly states that due to the inference drawn between the juxtaposition of conduct in question on the territory of a state immediately before crime committed on board a vessel or aircraft, means that the notions of conduct in crime in Article 12.2a of the statute have the same functional meaning. Your Honours, it follows that, as put by this court, at least an actus reus element of the crime must occur in the territory of the state. Your Honours, turning now to head of state immunity, counsel for the government has referred to this court's practice in issuing arrest warrants as evidence that a customary rule of law allowing for the removal of head of state immunity exists. This is an incorrect interpretation also. The issuance of an arrest warrant pursuant to Article 58 of the Rome Statute merely requires that there is reasonable grounds to believe that a crime has been committed within the jurisdiction of this court. Your Honours, we would not dispute that there is reasonable grounds to believe that this court can dispense with head of state immunity. After all, it is a contested issue, and this court's jurisprudence has put forth in the appeals chamber of the al-Bashir decision, specifically the Jordan referral, that head of state immunity can be removed before courts. What counsel for the prosecution has not identified, however, is that there is not the requisite state practice, nor is there the requisite opinio juris, to show the applicability of a customary rule of law allowing for the removal of head of state immunity. Counsel for the prosecution has not identified that the inverted legal burden was utilised in the appeals chamber decision in the al-Bashir decision. And counsel for the prosecution has also not identified that this court, merely because it has an international character, is completely different in nature to other international criminal tribunals. After all, it is not a court established by the United Nations Security Council, and as such, in the absence of a United Nations Security Council referral, this court does not have the erga omnes character that it requires to dispense with the head of state immunities of a non-state party. Now, turning finally to rendition, counsel for the prosecution has referred to the International Criminal Tribunal for the former Yugoslavia, specifically the case of Nikolic, whereas she notes that the irregular rendition, where it is not attributable to this court or the office of the prosecutor, does not allow for grounds of dismissal. Your Honours, that is also an incorrect interpretation. Whilst the government acknowledges that the office of the prosecutor or this court being involved in the rendition would of course be an aggravating factor in considering whether or not to dismiss the case, the court puts forth in the Nikolic decision that a consideration determining whether or not to apply the principle of male captus, bene detentis, is whether or not there has been a breach of sovereignty and whether or not that injured state has protested. They specifically noted that at the national level, after their survey of national case law on case dismissals and irregular rendition, that there is no circumstances in which states had formally protested. Your Honours, if I could ask for a brief extension to summarise. Thank you. Overall, Your Honours, given that the Government of Marine has expressly condemned the actions perpetrated by the Dothraki government, this court should refrain from exercising jurisdiction and serve its ultimate purpose in upholding the rule of law and being a neutral arbiter of justice. May it please the court.
Thank you. The prosecution, please.
Your Honours, I shall now proceed with my rebuttals on this matter. I shall deal with these rebuttals in the order in which they have been brought up in the preliminary submissions and the rebuttal speeches of both the defence and the government in this matter. Beginning with the rebuttals against the defence, we have two main submissions in this regard. Firstly, Your Honour, the defence has argued that the effects doctrine is inapplicable in this case by relying on the judgment of Bangladesh Myanmar by referring to paragraphs 56 and 57 of the judgment to highlight that they were simply a survey of domestic practice on this regard. Your Honours, while para 56 and 57 are indeed listing out manners of exercising jurisdiction over cross-boundary conduct over domestic jurisprudence, in paragraph 57, and I quote, it reads, "It is safe to assume that all the states reviewed are of the view that their domestic legislation on territorial jurisdiction over cross-boundary conduct are in conformity with international law and thereby possess opinio juris in this regard." That is, Your Honours, they have looked at both state practice and opinio juris for effects doctrine. Further, Your Honour, the prosecution once again re-emphasizes that we are in no way alleging that the Bangladesh-Myanmar case eventually applied the effects doctrine in its ratio. Instead, we agree that it applied the objective territoriality principle. We simply cite it to the extent of saying that the effects doctrine was shown to have requisite state practice and opinio juris in the realm of international criminal law, thereby making it fully applicable as a precedent before this court. For the second rebuttal, Your Honour, the defence has argued that the Lubanga appeals decision later overturned the position that has been argued by the prosecution. However, if I may read out paragraph 34 of the Lubanga appeals decision for this court, it reads, "Abuse of process is not listed as a ground for relinquishing jurisdiction in Article 17 of the statute." That is, Your Honours, they clarified that since the Rome Statute is exhaustive under Article 17 on the grounds on which you may challenge jurisdiction, you cannot import an extraneous ground such as abuse of process in this regard. We would also want to re-emphasize our position that has not been clarified by the defence or government as to there is no remedy for dismissal that has been provided under the Rome Statute, which has further been backed by the Lubanga appeals decision. With respect to the government, Your Honours, in their preliminary submissions, they have argued that even if the war crimes were considered to be a Hughes Cohen's violation, it would not impede the immunity of the head of state. However, paragraph 215 of the Jordan Appeals Decision's joint concurring opinion clarifies that in fact war crimes such as that under Article 82b3 are Hughes Cohen's violations of serious international concern and thereby displace any head of state immunity, which further applies in this case, displacing the head of state of immunity of the defendant before this court. Further, Your Honour, with a second rebuttal to the government, they have argued, as well as the defence, that conduct, crime and consequences shall be read in a certain way under Article 12.2a of the Rome Statute. However, we would simply like to clarify that we are not in any way reinterpreting the terms provided in Article 12.2a, but are simply reading in the effects doctrine as a general principle of international law alongside Article 12.2a and not conflating effects with consequences in this regard. Further, Your Honor, the government has argued that the arrest warrant against Mr. Putin and Mr. Netanyahu cannot be disregarded in this case. However, we would once again like to emphasize that the arrest warrant judgment by the ICJ has clarified that the mere issuance of an arrest warrant is a disregard of head of state immunity. Further, on our final rebuttal with respect to the al-Bashir decision as brought up by the Government Counsel, we would like to clarify that we understand that the al-Bashir decision involved a UNSC referral, which does not exist in this case. However, we are not comparing the facts of the two, as the al-Bashir decision eventually did not base its conclusion on the UNSC referral and instead on the fact that Article 27(2) is customary international law, which is what we're relying on this case, and not on the reversal of burden or the UNSC referral in this regard. Therefore, with these facts and evidence, we hope that the court prevents impunity in this case and upholds the decision of the pretrial chamber in its entirety. That concludes the submissions of the prosecution on this matter. Thank you.
Thank you. The bench will now leave the courtroom for deliberations. And now it's 11:35, and you'll be allowed to leave the courtroom, and you'll have 1 hour, and you will need to be present here at 12:35.
All right.
Court officer.